Good morning, everyone. Welcome to the second runner in this relay race.
Yes.
I am not batting cleanup today, but I am number two. And I will be doing elections. A little bit about me. As Jeff mentioned, I am a Florida Bar board certified condominium plan unit development specialist. I've been practicing association law pretty long time, since 1984. I've worked on both sides of the aisle, so to speak. I've represented developers, drafting documents. That was mostly in the Maryland area and Washington, D.C. for a few years. But for most of my career, I've been in South Florida representing associations. And as Jeff, I'm sure, has mentioned, as Danielle's probably mentioned, that is what our firm does. We represent associations primarily. That's, 90 X percentage of our business.
Right.
So that's enough about me. Not that exciting. Um, go University of Virginia, which was my undergraduate school. I'll have to mention that. Okay. So,
Yeah, it's
um,
bowl week, right? Or it was bowl week.
yeah, I was up there and they lost. So anyway, for the ACC Conference Championship game. Actually, so today, or my presentation, as Jeff mentioned, is elections, which is pretty timely since we are moving into election season, or actually in election season for some associations, but many associations have their elections over the next few months. So a little bit more about me, not that exciting. And we'll get into the meat of the presentation. Annual meeting and elections. Okay. First part we're going to be talking about is condominiums. Okay. Even though you're not getting credit for that today, that is the first thing we're going to be talking about. Let me get rid of some of that chat. Okay. So, how many directors? Very basic question. This is a basic question that sometimes causes problems because of the way the documents are written, especially older documents. And under the law, unless otherwise provided in the governing documents, a board consists of 5 members, except if a condominium which has 5 or fewer units, then the board consists of at least 3. Now, interestingly, if the bylaws do not contain a valid method for determining the number of board members, the board must be set at 5. And determining the number of directors at the election is not a valid method. So what does this mean? Basically, many documents, especially older ones, but there's many out there, will have a range in their articles and or bylaws that says the board shall consist of, say, not less than 3, nor more than 9, or it might say not less than 5, nor more than whatever. But if it just has a range with no method of determining within that range, or if the method is it's to be determined at the meeting itself, then basically it can't be determined at the meeting because you have to vote beforehand, which we'll get to in a few seconds or a few minutes. So long story short, pursuant to several arbitration decisions from the state, it defaults to 5. So the point I'm trying to make here is that if your documents have a range with no valid method, when I say valid, it would have to be way before the meeting of determining it, then you have a 5-person board. What about the term? Okay. Pursuant to law, pursuant to statute, the Condominium Act, the terms of all board members expire at the annual meeting, and such members may stand for re-election unless you have staggered terms. In other words, board members serve either 2 or 3-year terms, and it does not expire until a later annual meeting, or if all directors' terms would otherwise expire and there are no candidates. Although it's not on the slide here, also, all board members can stand for re-election unless the bylaws provide otherwise. So you can't have term limits built into your bylaws. And again, if permitted by the bylaws or the articles, board members may serve a term of longer than 1 year. You usually see that, as I mentioned, with staggered boards, where every other year or every 3 years, you're electing a certain number of boards, excuse me, a certain number of board members. Now, as of July 1st in 2018, the statute was amended to provide that a condominium board member may not serve, notwithstanding if your bylaws are silent, by the way, about term limit. There's a statutory term limit in that a condominium board member may not serve more than 8 consecutive years, which commenced July 1, 2018, unless, okay, there are 2 exceptions, unless approved by 2/3 of the members voting, not 2/3 of all, but 2/3 of those who actually voted in the election, or there are not enough persons are willing to serve. So this person who may be running into this 8-year term limit, they're allowed to run. So they're still eligible to run, but in order to be elected and serve, they have to either get 2/3 of the votes being cast, at least 2/3 of the votes being cast, or there has to be the same or fewer number of candidates as there are vacancies to be filled. Now, because if the number of vacancies equals or exceeds the number of candidates, then the election is required. So if you have, 5 vacancies and you have, 4 candidates, then they're automatically in. If you have 5 vacancies and there's 5 candidates, they're automatically in. You need more candidates than vacancies to require an election. Who's eligible to serve? Okay. Contrary to popular belief, all right, there's no statutory requirement that all board members must be owners. Okay. Your governing documents may require that board members be owners, but they may not. If your governing documents do not mandate that all board members be members of the association or owners, then they're not required to be. Pursuant to Chapter 617, which is the Florida Corporation Not-for-Profit Act, if a unit's owned by a trust, the grantor of that trust or the beneficiary of the trust who resides in the unit is eligible to serve. Also, a trustee of the trust is also eligible to serve on the board. Other eligibility requirements that may be in your documents are not valid. For example, I've seen some documents, not a lot, but I've seen enough that say you must be a resident owner. In other words, you can't be an absentee owner. You must be a resident owner to serve on the board. That is not enforceable. Okay. So those type of restrictions or those eligibility requirements are not enforceable. Since 2021, since July 1st of 2021, the statute, the Condominium Act, provides that a person who is delinquent in the payment of any assessment due to the association is not eligible to be a candidate. By the way, that's if you're delinquent as of the last day to submit your name into nomination. That's the deadline, which is, and I'll mention in another slide or two, which is the 40th day before the election. Previously, it said if you're delinquent in any monetary obligation, okay, like a fine or other fee, that is no longer applicable, and you must be delinquent in the payment of an assessment in order to be ineligible. Now, other eligibility requirements, okay, even if you're an owner. A person who has been convicted of any felony or has been convicted of any offense in another state, which would be considered a felony in Florida, is not eligible to be on the board unless that felon's civil rights have been restored for at least 5 years as of the date that the person is seeking election to the board. Also, a person who has been suspended or removed by the division, which is the Division of Florida Condominiums, Timeshares, and Mobile Homes, if that person has been removed by the division under the Condominium Act, they're not eligible to be a candidate either. Furthermore, in a residential, not a commercial, in a residential condo association or condominium association of more than 10 units, or in a residential condominium that doesn't have any timeshare units or timeshare interests, co-owners cannot serve on the board simultaneously or at the same time unless they own more than one unit or there are not enough candidates, eligible candidates, to fill the vacancies at the time of the vacancy. Finally, as we already mentioned, we'll mention it again, the statutory term limit is that a condominium board member may not serve more than 8 consecutive years unless approved, again, by the affirmative vote of owners representing 2/3 of all votes cast, not 2/3 of all, but all votes cast in the election, or there are not enough eligible candidates to fill the vacancies. Who is a candidate? A candidate means an eligible person who has timely submitted the written notice of their intent to become a candidate. Okay, when do you have to submit your intent? An owner desiring to be a candidate for the board must be eligible to be a candidate at the time of the deadline. Remember I mentioned before, if you're delinquent at the time of the deadline, then you're in paying an assessment, you're not eligible. Even if you become current after that, before the election, you're not eligible because that's the deadline. So any owner desiring to be a candidate for board membership must be eligible to be a candidate at the time of the deadline, which is not later than 40 days prior to the annual meeting where the election is taking place in order to be listed on the ballot. Now, it is a serious matter if ineligible candidates are placed on the ballot, including ineligible candidates on the ballot will jeopardize the election. Under the Florida Administrative Code, which has specific regulations, which are in addition to the Condominium Act. If the ballot includes the name of any ineligible person, then the association is required to mail, transmit, or deliver an amended second notice, which shall explain the need for the amended notice and include a revised ballot with only the eligible persons named on the ballot. However, if you cannot send that amended second notice in a timely manner, in other words, the time period for the second notice has already run, then you must renotice and reschedule the election starting with the second notice. Now, you don't have to go all the way back to the first notice, but you would have to restart it with the second notice. If your election has already occurred, then the election is deemed void and you have to renotice the elections again, starting with the second notice. What are the deadlines other than that 40th day? Okay, by the way, on that 40th day, the burden is on the owner, but we'll explain that, or on the candidate, and we'll explain it in a second. Not less than 60 days, and all these are very hard deadlines. These are strictly enforced deadlines. So not less than, 60 days before a scheduled election, the association must mail, deliver, or electronically transmit by a separate association mailing or included in another association mailing, delivery, or transmission to every owner entitled to vote a first notice of the annual meeting and the election. So what does that first notice say? It must contain the name of the association, the mailing address of the association, and disclose the procedure and deadline to consent to electronic voting if the board has previously authorized online electronic voting. So if it hasn't, you don't have to include that, obviously, but if you do have electronic voting, online voting, then you do have to have that deadline to consent to it, to cast your vote. Any owner or other eligible person desiring to be a candidate for the board, as we mentioned already, must give written notice to the association not less than 40 days before a scheduled election meeting. The owner must ensure proof of delivery, not the association. The association must give a receipt if the notice of intent to be a candidate is hand-delivered, otherwise it doesn't. That's why the state encourages owners or other candidates who are eligible to submit their intent by certified mail. Okay, so they have a receipt. There's two cases out there I always like to cite quickly, in which, in one case, the candidate, I think it was an owner, claimed that they slipped their notice of intent to run under the management door, the night before 11:58, p.m. before midnight. And the other one, they claimed they gave their notice of intent to the security guard, again, on the night of, before the deadline. In both cases, the arbitrator ruled against those owners, saying, no, you can't prove that it was delivered timely, therefore you're not eligible to run. So long story short, the burden is on the owner to prove that he or she has timely submitted their intent to be a candidate not less than 40 days before the election. Okay, upon request of a candidate, at the candidate's option, in essence, the association shall include an information sheet submitted by that candidate. Now, that information sheet, that's a technical name. You can call it a resume or other things, but it's technically called an information sheet. That must be no larger than 8.5 by 11 inches. Okay. Has to be furnished by the candidate not less than 35 days before the election. So 40th day is to submit your name to be a candidate. The 35th day is a deadline to submit this information sheet. If you do submit an information sheet timely, then that information sheet must be included with the second notice and the ballot, assuming that there's going to be an election. Okay, more notice and deadlines. Now, not less than 14 days prior to the annual meeting, and by the way, and not more than 35 days, it's not on there, but it's not less than 14 nor more than 35 days. Why 35? Because that's the deadline for the information sheet. The association must provide the second notice together with the written notice and the agenda. You have to mail, deliver, or electronically transmit that second notice of the election to all the owners, together with the ballot. The ballot lists all candidates alphabetically by surname. As I mentioned before, any information sheets must be submitted with that ballot. The ballot and the information that's provided with the ballot by the association cannot make any comments about any candidate, cannot indicate which candidate is an incumbent, cannot say anything pro or negative about it. Now, candidates can do their own campaigning, But in that mailing by the association, it has to be completely neutral with respect to all the candidates. Now, this notice, in addition to being sent to all the owners, it must be posted conspicuously on the property, not less than 14 days prior to the date of the annual meeting. And the person providing that notice and posting that notice and sending that notice must sign an affidavit indicating that those time periods were met for the annual meeting, as far as the notice. Websites. Okay. Currently, condominiums with 150 more units must have a website. Very, very shortly, though, that's being reduced because as of January 1st, 2026, the website requirements now apply to condominiums with 25 or more units. Okay, so in a few weeks, it'll be 25 or more units, or actually a couple of weeks, it'll be 25 or more units, not 150. Now, what has to go on that website in addition to a bunch of other stuff? The notice of any owner meeting and the agenda for the meeting shall be posted on the website not later than 14 days before the meeting. That notice must be posted in plain view on the front page of the website or on a separate subpage labeled Notices, which is conspicuously visible and linked from the front page. You must also post on the website any document to be considered and voted on by the owners during the meeting or any document listed on the agenda at least 7 days before the meeting at which the document or the information within the document will be considered. So if you're addressing other things at the annual meeting, in addition to the election, and there's documents that are going to be voted on as part of that, they must be posted on the website as well. Electronic notice, and this is not to be confused with electronic voting. We'll get to that in a few minutes, or voting electronically, which is another thing. But electronic notice, i.e. notice of meeting sent by email or by facsimile for those still using fax machines. Electronic notice can only be sent to owners who consent in writing to receive official notice by electronic transmission, typically email. So don't just email your notices to everyone just because that's how you do it. Owners have to agree in writing to receive your notices in that manner. Again, electronic voting we'll talk about in a few minutes. Any email address provided by an owner to fulfill those notice requirements is subject to inspection by owners. So I'm going to stop here for a second. Typically, email addresses of owners are privileged and are not accessible to other owners as part of the official records. However, if an owner has agreed to receive their meeting notices by email, then that email address is accessible to other owners as part of the official records. Also, an owner who consents to receiving notices by electronic transmission, i.e. email, is also solely responsible for removing or bypassing filters that block receipt of mass emails or filters that block receipt of them. So in essence, if you've agreed to receive your meeting notices electronically by email, and then your email system, your software, whatever, sends the association's things into spam or otherwise you can't access them, that's on you. That's on the owner. Okay. It's not on the association. It's on the owner to make sure that their filters do not block or remove the ability to see the association notices. Quorum. Okay. In a condominium, co-op, for an election, there is no quorum requirement, except the quorum requirement is at least 20% of the eligible voters must cast a ballot in order to have a valid election. Again, assuming there is an election because you have more candidates than vacancies to be filled. So you don't need a quorum other than that 20% of people eligible to vote casting their ballot. A new provision that was just passed this year is that if the annual meeting is conducted via video conference, okay, which is now permitted by law, a quorum of the board must also be physically present at the physical location where the unit owners can attend the annual meeting. Not sure why this provision was put in. It's irrelevant, what I think, because it is. Because back in the day, which is more than 6 months ago, the annual meeting again is not a board meeting; it's an owner meeting. So you didn't need a quorum of board members there. But now, under this new law, for the annual meeting, and not for other owner meetings, but for the annual meeting, a quorum of the board members must be physically present, not remotely, physically present at the location. Also, the annual meeting and the election must be recorded, and that recording must be kept as an official record if you are video conferencing the annual meeting. All this, what I've just mentioned is linked to or related to having a meeting conducted by video conference. While the election can be conducted without a quorum, you got to be reminded, or please remember that any other business can only be conducted if you have a quorum. So if you're going to be addressing, or the owners are going to be addressing other issues at the annual meeting, such as maybe voting on amendments to the documents, or voting on material alterations, or something else where the owners have a vote, for those matters, you do need a quorum to conduct that business, but not for the election. And also, as a reminder to everyone, you cannot vote in an election by proxy. You have to use ballots, and we'll talk about the ballots in a second. This is another new requirement with respect to location. If your bylaws do not provide the location at which the annual meeting is held, then it must be held within 15 miles of the condominium. It used to be 45 miles, now it's 15, or within the same county as the condominium property. Unit owner meetings, including annual meetings, may be, not must be, may be conducted in person or by video conference, but you still have to have a physical location. Okay, so you must have a physical location, but you may also do it by video. If the unit owner meeting is being conducted via video conference, any unit owner meeting, by the way, annual meeting or otherwise, if you're doing it by video conference, then the notice must include a hyperlink and a call-in conference telephone number for the owners to attend the meeting. The notice, as I just mentioned before, must also include a physical location where owners can attend the meeting in person. So you can't force everyone to attend remotely or by video. The video conference must be recorded, and that recording must be maintained as an official record of the association. This is for any owner meeting. An owner may vote electronically in the manner provided in Section 718-128, and we'll talk about that in a few minutes. What does video conference mean? Well, the term video conference has been defined statutorily as a real-time audio and video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. As part of the election process, and really the first part, which is this is the first order of business at the annual meeting, or if you call a separate meeting, is to verify or confirm the ballots, the outer envelopes. So the association may do that, again, at the annual meeting as the first order of business in front of the owners, or you can verify the information on the outer envelope prior to the election by noticing a meeting of an impartial committee. Okay, this committee, by the way, it's the same committee at the annual meeting who's going to count the ballots, of an impartial committee consisting of members who are not current board members, officers, or candidates for the board, or any of their spouses. Okay, this meeting of this impartial committee must be held in accordance with section or rule 61B 23.0021. That's part of the Florida Administrative Code. And it must be open to all members, and it must be noticed just like a board meeting. In other words, you have to post at least 48 hours notice conspicuously on the property of your committee meeting at which they are going to verify the outer envelopes for the election. Now, at that meeting, the signature and unit number on the outer envelope must be checked against a list of qualified voters who will be checked off on the list as having voted. Any outer envelope that's not signed by the eligible voter must be marked with the term disregarded or words of similar import, and those are put aside, and those ballots are not counted. Now, that ballot envelope is not opened, but it's marked disregarded, and it's put aside and not counted. Like I mentioned before, you can also do the verification at the annual meeting. Also at the annual meeting, the first agenda item is the election. It's the collecting of any ballots that have not yet been cast. And the association must have blank ballots and the ballot envelopes, inner and outer envelopes, at the meeting for those owners who are going to vote in person at that meeting by turning in their ballot then, as opposed to having it dropped off or mailed in earlier. Very important. Once a ballot is received, it cannot be rescinded or changed. So if an owner submits their ballot and says, "Oh, wait, I screwed up. I didn't mean to do this." Well, too late. okay, once that ballot is in the association's hands, it cannot be rescinded or changed. Okay, opening and counting. In the presence of any owners in attendance, and this means something, you can't just, and I have this argument sometimes in annual meetings where they do the counting in some other room or in the hallway or away from those who are in attendance. And I always have to get in a little bit of a tiff with the people and say, no, they have to do the counting in here. So basically, it has to be in the presence of any owners in attendance. And regardless of whether a quorum is present, as we mentioned before, all the inner envelopes, okay, after you verify the outer envelopes, you remove the inner envelopes from the outer envelopes and you separate them. Now, why do you do that? And you put the inner envelopes in a receptacle? Well, this is again to ensure the secrecy of the vote. So all the inners are removed from the outers, so you don't know which ballot goes with which unit. Now, upon commencing of the opening of those outer envelopes or accessing the electronic vote for those voting electronically, whichever happens first, that is basically when the polls are closed and no more ballots are accepted. So as soon as they start opening up those outer envelopes, if someone rushes into the meeting and says, "Oh, that's too late." Okay. So once the verification process has been completed and they start opening those outer envelopes, or the electronic votes have been counted, then no more ballots are cast. Then after they're separated, the inner envelopes are then opened and the ballots removed and then counted again in the presence of the owners, not in some secluded area or other room. Any inner envelope containing more than one ballot is marked disregarded or with the words of similar import, and any ballots contained therein shall not be counted. Although if you own multiple units, you can't put in your envelope separate inner envelopes for each ballot. That's if you own multiple units. But if there's multiple ballots in there for a single unit owner, no. All envelopes and ballots, whether disregarded or not, shall be retained with the official records of the associations. In essence, keep everything. Okay, don't throw anything away. Got to keep all that stuff. And the election is decided by a plurality of the votes. And what does that mean? Who gets the most votes? Okay. X candidates who receive the most votes are elected. You don't have to receive a majority of all the votes cast. You just have to get, those receiving the most votes. What if there's a tie? Okay. If there's a tie, okay, between two or more candidates, which would result in one or more candidates either not serving or serving a different period of time. In other words, if you're determining who serves a 1-year or 2-year term or 3-year term, then unless otherwise provided in the bylaws, you conduct a runoff election. So how is the runoff election done? Well, within 7 days of the night or the date of the election, at which the vote occurs, the board shall mail or personally deliver to the owners a notice of the runoff election. Who's in the runoff? Well, it's the candidates who were tied, obviously. So the only candidates eligible for the runoff are the runoff candidates who receive the tie vote. The notice shall inform the owners of the date scheduled for that runoff election to occur, must include a ballot. Now, the ballot form is the same as we did before, except it only has those runoff candidates on there, and shall include copies of their information sheets. So if they had information sheets submitted previously, those information sheets are included again. Again, the information sheet is optional. It's not mandatory. But if those candidates submitted information sheets, those information sheets are then included in the runoff notice election package. The runoff election must be held not less than 21 nor more than 30 days after the date that the tie vote occurred. Electronic balloting, okay? Now, this is new. This is not the online electronic voting. This is a different form of this is basically email voting. Okay, it's the best way I can describe it. It's how it should be described in the statute, but they call it electronic ballot. It's an email ballot. Okay, unless the association has adopted electronic online voting. Okay, if you've had that, you don't do this other type of electronic voting. But if you have not adopted electronic online voting, then you must designate in your second notice, okay, an email address for receipt of an electronically transmitted ballot, i.e. email ballot. An owner may electronically transmit a ballot to the email address designated by the association without complying with Section 718-112, which is basically the stuff about the inner outer envelopes for ballots. Okay, this is not an inner outer envelope. This is an email ballot. And you also don't have to comply with the secrecy. Okay. So this is a way to vote electronically, but you're waiving your secrecy. So an owner must transmit their completed ballot to the email address designated no later than the scheduled date and time of the meeting. So this is different. Remember I said before, the polls close when they start opening those outer envelopes, except if you're voting by email, okay, then you must submit your email no later than the date and time of the meeting. So if the meeting is going to be at 7 p.m. on January 15th, then that email ballot, if the owner is submitting one, must be submitted by 7 p.m. January 15th. Okay, what goes on these email ballots, or what is the form of them? Well, okay, I'll talk about that now. The association must count completed ballots that are electronically transmitted to the email address so long as it includes the following. So this is the form. There must be a space for the owner to type in their name, his or her unit number, and a space for the owner to type in his or her first and last name. So unit number and first and last name in the spaces provided on the ballot. Now, that typing of their name functions as the signature of the owner for purposes of signing the ballot. Now, importantly, you have to have the following statement, which is on your all screen, in capitalized letter in the biggest font than any other font used in the email. And basically, what that says is that the owner acknowledges that waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy to participate in the vote that is subject of this ballot, please vote in person during the meeting at which the matter will be voted on, or you can mail in your ballot the old-fashioned way. So that disclosure must be on the ballot form as long as the information that we just discussed. Electronic voting, again, this is the online voting, which is when you can sit at home and then click as opposed to mailing in or emailing in. If at least 25% of the voting interests of a condominium association petition the board to adopt the resolution for electronic voting for the next election, the board must hold a meeting within 21 days after receipt of that petition to adopt that resolution. The board must receive the petition within 180 days after the date of the last scheduled annual meeting. So basically within 6 months after the last scheduled annual meeting and election. Now we're going to segue from condos into homeowner associations and their annual meeting and election requirements.
And thanks for your patience, everybody. We had to include everything in order to give managers their credit as well. Peter, back to you, sir.
Okay. That was a commercial interruption. All right. Board terms and eligibility, HOAs. It's different than condos. The governing documents may require that the board members be owners. There is no maximum term length or term limit. So we don't have all that term stuff in the HOA law. Members are eligible to serve on the board unless they're ineligible because of a specific reason. We'll talk about it in a minute. But similar to condos, unless your documents limit board members to being owners, they don't have to be owners. Now, however, a person who has been convicted of any felony, who has been convicted of any offense in another state, which would be considered a felony if committed in Florida, is not eligible for board membership unless their civil rights have been restored for at least 5 years as of the date such person seeks election to the board, which is basically the date or the last date that you can nominate yourself to be on the board. A person who is delinquent in the payment of any monetary obligation due to the association is not eligible, again, as of the last time or date you can submit your name. Remember, this is different from condos. In condominium associations, it's delinquent in the payment of any assessment. Here, it's delinquent in the payment of any monetary obligation. So that would include assessments, fines, fees, or other things. Now, pending charges of felony, theft, or embezzlement offense involving association funds, not just conviction or charges, makes you ineligible. Co-owners and HOAs are permitted to be candidates and serve on the board. So there is no requirement, there is no prohibition against that as there is in the condominium association. And there's no other eligibility requirements that are valid. The association must hold a meeting of its members annually for the transaction of any all proper business at a date, time, and place that's fixed or provided by their bylaws, sometimes articles, almost always the bylaws. The election of directors, if one is required to be held, must be held at or in conjunction with the annual meeting or as provided by the association's governing documents. All notices for member meetings must provide the date, time, and location of the meeting. If the bylaws don't provide for giving of notice or for providing notice to the members of membership or owner meetings, the association must mail, deliver, or electronically transmit notice to all owners not less than 14 days prior to the meeting. That has to be evidenced by an affidavit executed by the person providing notice, and that must be kept with the association's official records, similar to the condominium requirement. What about electronic or email notice? Notice by electronic transmission of meetings. However, similar to condos, an owner must consent to receive their notice electronically. Okay, and an affidavit of notice must be kept with the official records. So similar to condos, you have to agree to receive your notice electronically. Now we have this big giant warning sign that we're all in trouble. We're not in trouble, but this is important just to remind everyone that the election of directors must be conducted in accordance with the procedures set forth in the governing documents. I'll stop here for a minute or two. The condominium elections are governed by statute. So statutorily, it has the procedure. We just mentioned it, the 60-day notice, first notice, the 40th day to submit your name to be a candidate, and then the second notice, the 35th day for your information sheet, and then the second notice, not less than 14 days, no more than 35 days, and the whole rigmarole with that. HOA is completely different. The governing documents, i.e. the bylaws, govern the procedure for the annual meeting. The statute, except for a couple things we'll talk about in a second, doesn't set the procedure. And I've run into many situations where HOAs are automatically following the condominium law for whatever reason, even though their bylaws are different. And that's wrong, okay? Because although that's a nice procedure and you may like it, you have to follow your bylaw procedure. Now, some bylaws in the HOAs do mirror or parallel the condo law. Some don't. Long story short, you got to go through your documents for the election procedure for an HOA. Now, effective July in 2013, if the election process as set forth in the governing documents allow candidates to be nominated in advance of the meeting, then you're not required to allow nominations from the floor at the meeting. Otherwise, you do have to have nominations from the floor. This is contrasted directly with condos where there are no nominations from the floor. They're not permitted. In an HOA, there may be nominations, may not be nominations. It depends upon whether there's a pre-nomination process in which owners or eligible candidates can nominate themselves. Again, if there is, then you don't have to have the nominations from the floor. Quorum. Remember we talked about condos where there is no quorum for an annual meeting and an election? Well, in HOAs there is, okay? So except for one circumstance I'll mention in a second, a quorum must be established in order to conduct an election and any other business of the association at the annual meeting. Unless a lower number is provided in the bylaws, 30% of the total voting interest shall constitute a quorum, but you have to check your bylaws out. And no quorum at a meeting means that the board is going to hold over only until the next election. The exception, which is not on the slide, but the exception to this is if you have a pre-nomination procedure in your HOA. Okay, in other words, where candidates nominate themselves in advance of the meeting by some kind of system, some kind of methodology that's in your bylaws, and there are the same or fewer number of candidates as vacancies to be filled. So in essence, you don't have more candidates and vacancies. And those two circumstances together, then there's no quorum requirement. And those people are automatically on the board. So that is the exception, the one exception to not having to have a quorum at your annual meeting. Unless, again, your documents, your bylaws, and your election procedure have a different quorum requirement or address this differently. But again, you have to check out your bylaws, like we said before, for your election process procedure. Election day, ta-da. In an HOA, owners, members have a right to vote in person or by proxy unless otherwise provided by the governing documents. Again, condominium associations, there is no proxy voting for elections. In an HOA, there can be or there might be, but again, it depends upon your governing documents. If they're silent, then they are allowed to vote by proxy. So you have to check it out. If the governing documents, again, if permit voting by secret ballot by secret absent ballot, actually, for those who are not in attendance. So if the governing documents permit secret absentee balloting, then similar to condos, the ballot must be placed in a blank inner envelope with no identifying markings and mailed or delivered to the association in an outer envelope identifying the name of the owner, the lot, the parcel, lot, and the signature of the owner casting the vote. So that's very similar to the condo. And all ballots and proxies are tabulated on the day of the annual meeting. How do you fill vacancies that occur between annual meetings? Vacancies, in other words, that occur because of resignation or death or disqualification. We'll address that now. Unless otherwise provided by your bylaws, any vacancy occurring on the board before the expiration of a term can be filled by the affirmative vote of the majority of the remaining directors, even if it's less than a quorum, or even if there's only one director that is remaining. He, she, they fill those vacancies. Alternatively, the board may call an election. In my experience, that usually does not happen. Usually they appoint to fill those vacancies, but they can call an election. How long do they serve? Well, unless otherwise provided by the bylaws, a board member appointed or elected to fill a vacancy that occurs, again, because of a resignation or a death or something before the expiration of the term, that person serves for the unexpired term of the seat being filled. Okay, so if the documents are silent or don't provide otherwise, then it's the unexpired term. Sometimes you'll see in the bylaws that they fill the vacancy only until the next annual meeting. In that case, that would control. But in the absence of that, it's for the unexpired term. The recall law is different, and filling vacancies created by recall is very specific. We're not addressing that today, but that is another specific way in which vacancies are filled. Electronic voting for condos and HOAs, condominium associations and HOAs. Okay, now here we're talking about online electronic voting, not the email. And by the way, that email thing, it only applies to condos. An association may use an online voting system for all owner votes if an owner provides written consent to online voting, which is valid until the owner opts out. Again, assuming the association has adopted the online voting. Okay. An owner voting electronically is counted as being in attendance at the meeting for purposes of determining or establishing the quorum. The use of electronic voting must be established. Again, this is must be established by resolution at a board meeting, notice at least 14 days prior to the meeting by mail, delivery, or electronic transmission, and posted at the community, evidenced by an affidavit. Now, that board resolution adopting electronic voting must provide that owners will receive notice of the opportunity to vote through an online voting system, must establish reasonable procedures and deadlines for owners to provide their written consent, and establish reasonable procedures and deadlines for owners to opt out of online voting. If online voting is used, the association must provide every owner with a method to authenticate the owner's identity, a method that is consistent with the association's election procedure and bylaws, and a method to confirm that at least 14 days before the voting deadline, that the owner's electronic device can successfully communicate with the online voting system. And the association must use an online system that is capable or able to authenticate an owner's identity, authenticate the validity of each electronic vote to ensure that the vote is not altered in transit, transmit a receipt to each owner who casts a vote online, permanently separate any authentication or identifying information from electronic election ballots, rendering it impossible to tie a ballot to a specific owner, and store and keep the electronic votes accessible to election officials for recount, inspection, and review purposes. So that system has to be able to accommodate all those things. What about officers, okay, of HOAs and condominiums? Well, typically, and almost always, you have to check your bylaws, but generally, pursuant to the documents, officers are elected by the board, usually immediately following the election of the directors. That's what is known as the organizational meeting of the board. Now, directors at board meetings cannot vote by proxy or by secret ballot at a board meeting, except the only exception is you can use secret ballots to use in the election of officers. So although generally directors cannot vote by secret ballot at a board meeting, they can when they're electing officers. And also, there's no prohibition against changing officers midstream, unless your documents have some unusual provision. So, oftentimes, you'll elect your president, vice president, whatever, and then halfway through the year or whatever, the board can have a meeting and change those officers. It doesn't take the person off the board. Okay, they're still a board member because the board cannot remove directors from their seats on the board. They can remove them from their office as a president, vice president, treasurer, whatever, because those two things are different. What about certification requirements, that you have to comply with? And this is for residential condominiums and HOAs. Okay. For condominiums, okay, board member certification now requires both written certification that you've read the governing documents and will uphold them and meet your fiduciary duty to the best of your ability, and attendance at a division-approved education course. Up until very recently, a board member for condo could do either one. They could either sign the written certification that they'll uphold the document, they've read the documents and they'll uphold them, or take the course by a division-approved provider, but now they have to do both. Now, the board member certification course must be at least 4 hours long and provide instructions on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, and notice and meeting requirements. It is a long course. I teach it, as well as others here in the firm, but it does contain a lot of information, the board member certification course. All board members must be certified within 90 days of being elected or appointed to the board, or within 1 year before that, but can receive their written certification up to 1 year prior, as I just mentioned, to being elected. Again, it's both, the written certification as well as taking the course. A director of an association of a residential condominium who was elected or appointed before July 1st of 2024 must comply with these certification requirements by June 30th, 2025, which was 6 months ago. Continuing education. So as Jeff mentioned in his intro, we now also have continuing education requirements for board members. So for a condominium association, each year after being initially certified, all board members must take continuing education courses and provide a certificate of having satisfactorily completed at least 1 hour of continuing education related to recent changes to Chapter 718, which is the Florida Condominium Act. So that's 1 hour per year. What about the certification? The certification is valid for 7 years, that initial one, after the date of issuance, so long as the director serves on the board uninterrupted. They go off the board, come back on. This is in addition, obviously, to the continuing education requirement. The association must maintain proof of the written certification and education certificate, both, remember, written certification as well as taking the course, for 7 years after the director's election or appointment, or the duration of director's uninterrupted tenure, whichever is longer. Okay, so it's at least 7 years. However, failure of the association to have proof of the board member certification and proof of the continuing education does not affect the validity of board actions taken. HOAs, it is different for homeowner associations than for condos. This part is, well, an elected or appointed director must complete the department-approved education for newly elected or appointed directors within 90 days after being elected or appointed. You have to take the course. The written certification is no longer applicable to homeowner association board members. So condo board members, as I mentioned before, they both have to sign that written certification and take the course. For HOAs, there is no more ability to be certified by signing a certification. You must take the course. A director must complete the education specific to newly elected or appointed directors at least every 4 years. So it's a shorter term of validity, 7 years for condos, the certification for HOAs, 4 years. The curriculum specific to newly elected or appointed directors must include training with respect to financial literacy and transparency, record keeping, the levying of fines, and notice of meeting requirements. What about continuing education? It's also different for HOAs directors. A director of a homeowner association that has fewer than 2,500 lots or parcels must complete at least 4 hours of continuing education annually. A director of an association that has at least 2,500 lots or parcels must complete 8 hours of continuing education annually. Why is this different than the condominium associations? I have no idea, but it is. So just be aware, the continuing education requirements and the certification requirements for condo association board members and HOA board members are different, and follow what's applicable to you, obviously. Proof of certification. Now, the association for HOAs, we're continuing with that. The association must retain the educational certificates for newly elected or appointed directors for a homeowner association for 5 years. However, the failure to have it, again, does not affect the validity of any board member actions. Valid for 4 years. As we mentioned before, the certificate is, or the certification is valid for 4 years. A director who does not timely file the educational certificate for a newly elected or appointed director is suspended from the board until he or she complies with that requirement, and the board can temporarily fill that vacancy until the suspension is removed, in essence, or until that board member becomes certified, or that person becomes certified.
Peter, I just want to quickly address something because Deborah mentioned something in the chat, and I know others get confused about the education requirements for HOA board members and board members in general. This is it, and I think this is a clear example. And I know we covered some condo stuff today, even though this is advertised as HOA, CEU, and CAM CEU. The reason we covered some of the condo stuff is because we have managers here as well. Everything the HOA board member needs for the credit is in this class, so no worries there. You're going to be covered. You're going to get your certificates. Now, the confusion usually lies with the term. The acronym HOA is used way too loosely in this industry.
Okay.
You know, and I think that that's where some of the confusion comes in. So people who live in a condo and a co-op, they get asked, "Hey, how much do you pay your HOA? You know, how much do you pay for your HOA?"
Yeah, the term gets thrown around loosely. Do you want me to explain what the difference is?
No, I just want to just mention,
Okay.
we even have managers that are sending people to the wrong classes often. So I just want to get people into the habit. If you live in a condo, don't refer to it as an HOA, even if some of the concepts are the same. If you live in an HOA, you're governed by 720. If you live in a condo, you're governed by 718, so on and so forth. So I think that's where some of the confusion comes in, is that even we even have managers sending their board members to the wrong classes quite often. So anyway, I just wanted to throw that in there because this question came up in the chat, and I know it's going to come up again.
And then I'll just mention real quickly, just as one way to easily distinguish this, because there's all sorts of names. There's also POAs, right? So
Right.
property owner associations. That confuses people too. Okay. If you live in a community and it's a high rise, okay, you're either in a condominium or a co-op. Okay. Right. Because
Yeah.
you're not going to have a high rise HOA. If you're in a community where you have a declaration of condominium, you're in a condominium association, because a declaration of condominium does not apply, and you must have one to create a condominium. If you're in a community with a declaration of covenants, restrictions, or protective restrictions, but not a declaration of condominium, you're in an HOA. That's kind of a shorthand way to figure out what the heck you have, because you can have single-story condominium, so
Right.
you can, but you cannot have a high-rise HOA.
HOA. Yeah. No, thanks for even further clarifying that. Again, we even have managers sending their board members to the wrong classes. I see it all the time. So Peter, back to you, sir. Sorry for the
Back to
interruption.
me. Thank you, Jeff. Back to our regularly scheduled programming or something like that. Okay, so we finished that slide and we're on to the next one. Okay, which is election records and disputes. Again, both associations. When can you challenge an election? Okay. Well, for both HOAs and condominium associations, this does apply to both. Any challenge to the election process must be commenced within 60 days after the election results are announced. So generally after that day or night after that meeting, when they announce the results, people have a 60-day, or owners have 60 days to challenge. Okay. What's part of the official records? Well, basically everything. The ballots, the sign-in sheets, any voting proxies, if you have any, and all other papers or documents relating to voting by owners shall be maintained for a period of 1 year from the date of the election, vote, or meeting to which that document relates. The notices of the meetings, though, first notice, second notice, or an HOA, whatever notice your documents require, must be kept for 7 years. As of July 1st of 2021, the challenge may be brought as a petition for arbitration with the Division of Florida Condominium, Timeshares, or Mobile Homes, or as an action or a lawsuit in the applicable circuit court. Wow,
I
I
think that's
finished.
it. Yeah.
Okay. So I hope it was educational or somewhat interesting, and thank you all for listening. Um,
Absolutely.
did
Peter, you
I
did a great
actually finished? Wow, look at that. On time.
finished on time. There's if you have an extra few minutes, we can address some of the questions in
Sure,
the
we can
Q&A.
have me dodge a few questions.
But
Not
before we do that, folks, I just want to mention we will go over a few of the questions. And for those of you came on expecting HOA only, um, I can appreciate that, and we do appreciate your patience with these complimentary webinars. We try to cover several birds and stones, or whatever the cliche is, with the one class because of how busy our attorneys are. So to get so if we can kill two birds with one stone in one class, we do that. So in the chat module, I'm going to place the evaluation link one more time. Click on that, fill that sucker out. After you fill out the evaluation, you can go. The Q&A part is bonus. Don't have to be here for that.
I mean, if it's a poor evaluation, you can just keep it. Don't feel any urge to send it in. Just
But
kidding.
let's get to a few of them. We'll do a handful of them so everybody can get a break for lunch and come back for our next class in about an hour.
As the relay race continues.
Let's see here. Let's the one that's coming up most often. Peter, how do we interpret the frequency of how often somebody has to take a CEU class? Like Bruce is asking, continuing education annually, is it the calendar year? Because he has heard it's from June 30th to July when the new laws come out, which is kind of how
Oh,
I interpret it.
good question. Not sure. I don't think it's been any interpretation of that. I guess I was thinking of when you got elected. But
But you need that certification class.
yeah. That's a good, you know what? I'm not sure.
You
Uh
know,
I'm not aware of any, this is all new. I'm
I'm
not
sure they'll
aware,
clarify it somewhere down the road.
yeah, I'm not aware of any specificity about that. I think it definitely would be if not from the election date, then from when your certification was done. Either of those. I'm not trying to dodge this question too much, but as far as I recall, it's not specified yet. I
Yeah.
don't.
Yeah, it's not specified, and I think part of that thinking that he mentioned, and what several others have noticed, is that when the new certification classes were passed a year and a half ago, those new certifications talked about board member continuing education a year and a half before they approved any CEU classes for board members.
Yeah.
So I think that's where some of that interpretation comes
Well,
from.
it was all a giant mess
It
for
was
a while. Conservatively, I would go by, to me, annually means annually during your term. Okay. That's,
after you take your certification class.
yeah, that's kind of how I would interpret it, but it's a
Yeah.
good question.
And it's never a bad thing to take these classes annually anyway, because things are always changing and we update these classes to reflect any changes that
And
take
hopefully
place.
you turned in your evaluations before I flubbed up that question.
You can't
Someday.
flub up something where there's no clarification to
Yeah,
begin
there's
with.
no clarity. There's no real clarity on that I'm aware of, but maybe
Can
I'll have
HOAs?
check that out and he can talk about it in his next presentation.
Let's see. Can HOAs use email electronic voting by an authorized electronic voting vendor? Email.
Email, it's not in the statute.
It's
So not
condo.
statutorily. Perhaps if it's in their bylaws, since the statute does basically say that your bylaws control. But then again, law says vote in person or by proxy. I'm leaning towards no on that, but it is an open issue and not a case on this where the statute does say you follow the procedure in your bylaws. So if your bylaws expressly say you can do it, maybe.
Okay. Must a candidate Must candidate info sheets, also known as resumes in some cases, also be posted on the website prior to the election? So not can they, but must they be?
I don't think that's a must. Yeah, they can. I don't think it's a must.
Okay. Let's see. If the member has served 7.5 years from July 1, can he or she run or they run again in the February 2026 election?
What?
Yeah, that's not clear enough. Hang on here. For ballot, let's see, blah, blah, blah. I'm trying to stick with HOA questions. Okay. Did I hear that someone who nominates themselves ahead of time automatically fills a vacant seat,
No,
even
that
if
is
there's no quorum to have an annual meeting?
that is not true.
Okay.
What, just to clarify that, if your HOA has a pre-nomination process, okay, so that's number one. There has to be a pre-nomination process in their bylaws. And if there are the same or fewer number of candidates, okay, who nominate themselves, then and there's no nominations required from the floor because you have that pre-nomination process, then there's no quorum requirement.
Okay.
So you're not automatically on the board. Depends how many people nominate themselves, in
Okay.
essence, and whether or not you need an election for a quorum. I got a quorum for an election.
For an election. Regarding we already know certificates have to be posted on the website as part of the records. What
Yes,
about the 1 hour the affidavit affirmation? Does it have to be on the website too?
the affidavits go on the website too.
As well.
The affidavits, I know they're part of the official records. I should have this memorized. I think they go on the website, but I'm not positive.
Okay.
But they are definitely part of the official record. But I think they also go on the website.